Okay, so what I'm reading in the report is, you know where the complainant lives, because this allegedly happened where the complainant lived. Court is calling 2022 CR 9493, State of Texas versus Herbert King. Can I have parties announced for the record for the state,
Jason Garrett, Your Honor.
for the defense?
Monica Guerrero is the attorney of record. Joseph Stateson, assistant attorney. District King, would you give this court permission for me to be in place of Monica Guerrero?
Yes, sir.
All right, and are you Herbert King?
Yes, ma'am.
Counsel, have you received all the discovery in this case, and did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. King, I'm going to show you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it, and did you sign it? Next, I'm going to show you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on an indictment as presented?
No, Your Honor, we're waiting the additional enhancement paragraphs.
Any objection?
No objection.
Mr. King, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it, and did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with burglary of a habitation with the intent to commit assault? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
She has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. King, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 5 years in prison. There's a $2,500 fine. State is silent on your applications. There's to be no contact with Donald Clark and Kiki Davis, and they're waiving the enhancement allegation. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it, and did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. State exhibit number 1 with all its attachments.
No objection.
Mr. King, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. All right, your sentencing date will be for March 23rd at 9 a.m. The court will base its decision on your application based upon the PSI report and any other evidence that is presented to me. Do you understand?
Your Honor, my client.
Oh, March when? Okay, it's March 6th.
Your Honor, my client did wish to make a request regarding conditions of bond. He's on a monitor.
Yes.
He's had no violations. We understand that conditions of bond drop off after his sentence, but he's asking if perhaps monitor can be lifted today.
All right, so what is the conditions of the monitor? Is he on tracking? What's going on?
GPS mode.
No, I mean, I know it's GPS, but are you on a curfew? Are
Yes,
you?
ma'am, and I just recently started a new job and it's starting to affect my job. Like I can't. They have to set me at a certain time to be in, a certain time to be out, and a lot of times I walk back and forth to work. So they only giving me like an hour before, and it's like an hour, maybe an hour, 45 minutes for me just to walk to work.
All right, state.
State's not opposed if he has a employment, Your Honor, but the state would ask that he would is told not to contact the victims in this case or the witnesses in the case.
Okay, so what I'm reading in the report is, you know where the complainant lives, because this allegedly happened where the complainant lived. So you know you're not supposed to be on those streets. You know you're not supposed to contact the complainant, and that includes the complainant and your ex-fiance.
Yes, ma'am. I'm fine with that.
Well, here's the thing. People tend to ignore when people have X in front. But X means it's over. Ex-wife, ex-husband, ex-girlfriend. The only people you can't put X in front of is ex-children.
You
You never heard that. No, you never heard that, even when they ask for money.
No,
So-
no, I respect that. She's moved on, I've moved on. I actually have a baby on the way, so I'm trying to do what I need to do to be there in my child's life. That's
All right, so we can do tracking, but he is not allowed to contact the complainant at all or contact his ex-fiance.
that's fine.
And I put my hands in quotes because I want you to realize it is X. That's what that means, no
Yes.
contact. She doesn't want you anymore.
Oh, my fiance will kill me.
Yeah, yeah, well, then guess what? You won't be on probation. So, but she is X,
Yes,
okay?
ma'am. Yes,
So
ma'am.
if you can bring an order to the court, and actually they're telling me that your setting date is March 6th.
I will get an order sent to you. Thank you, Judge.
All right, thank you.
Your Honor, off the record.
Yes.
I have a fun joke I heard if you like to hear it.
Yes, I would love to hear the joke.
Why did the boy throw butter out the window?
Wait, why did the boy do what?
Throw a stick of butter out the window.
Oh, because he wanted to see a butterfly.
That's gonna go on the PSI, right?
Yes,
All right, so we are back on the record in 2022 CR 10140, State of Texas versus Mark Johnson. Has your client made a decision?
Yes, Judge, it was a quick decision. He had already paid up at this stage, just wanted to go some legalities of it, but he got to jump.
Okay. All right, then this is what the court will do. Court will sentence you to 8 years deferred adjudication. I'm going to want gang supervision, proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors, Mr. Porter. Once he's in his sobriety, then the court may consider that. But for now, no unsupervised contact with minors. Ms. Abrams, I don't know if Child Protective Services is involved in this case or not, but if they are, I'm going to want CPS compliance. I'm going to want regular reporting by Zoom or in person. Field visits 3 times per month. A referral to felony drug court. And if he's not accepted in felony drug court, then I'm going to want safety. And he's to remain in custody until accepted. In felony drug court or safety. There's to be restitution and no contact with Hector Vega. Taking consideration 2022 CR 10141. 2022 CR 10142. the UA hotline upon release. And he's to be tested at least once a week. And state, you can, I'm sorry, state, I meant probation. You can lower that as you all see is appropriate. And I'm going to want 90 meetings in 90 days upon release. Probation, is there anything else he needs? I'm sorry, parenting classes. And those parenting classes will be with Triple P. 250 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. The remaining hours will be waived upon completion of parenting classes. Probation, is there anything else he needs? Is there anything else you need for me to be successful on this probation? All right, why you have your head back like you're trying to be hard with me? All right, so do not come to the court trying to be hard because this is not the streets. You understand? Do you understand? All right, thank you. We're dressing appropriately for trial. Everybody who's come up is dressed appropriately for trial. I don't know if that's defense attorneys or people just having great fashion sense. So thank you, defense. All right, so we were here last time on January 12th for discovery, and it is reset to make sure that everybody has their discovery. So does everybody have their discovery?
Not yet, Your Honor, but we're one step closer.
Okay, why don't we have the discovery? And this is this.
We did receive the records. However, it was brought to my attention by defense counsel that when they were scanned in, they were not marked discoverable. So I went through this morning and marked them discoverable. So she should be able to view all 51 pages tomorrow morning once the system refreshes.
All right, Ms. Ferguson, I need a 30-day reset on Mr. Herrera.
That one on the 23rd.
All right, and state, did you tender an offer?
Yes, there's an offer.
All right, so this is going to be set for the 23rd, and the 23rd will be your plea deadline date.
Your Honor, there's two issues that we do need to bring up.
All right, what are the two issues?
The first one is I had approached the court and the state regarding a motion to amend conditions of bond that I filed. My client asked me to be able to ask the court if he could have the court's permission to go to Sunday church services with his family. I did confer with the prosecutor. She stated that they are in opposition to it. So we decided, since we were set for today, we could go ahead and approach on that motion today.
Oh, we can, do you want to place it on the record, counsel?
We can't, I'm sorry, I thought we were on the record.
No, we're not on the record. So that all defense attorneys know, and you can go forth and tell defense attorneys that we are on the record when I call the case number and the style of the case.
I apologize.
Oh, no problem. Court is calling 2022 CR 0147, State of Texas versus Michael Herrera. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
And Jessica Gonzalez for Mr. Herrera.
All right, and are you Mr. Herrera? All right, the defendant has, through his attorney, has filed a motion to amend both bond conditions requesting that he be allowed to attend church services with his uncle from 10 a.m. to 1 p.m. at St. John's Lutheran Church. State, have you had a chance to review the motion?
We have, Your Honor.
And state, are you opposed?
We are opposed.
All right, and state, why are you opposed?
Your Honor, of course, the nature of this crime is a touching of a child, and with church, there are always children. And so our concern is unsupervised contact with children that might occur at church.
All right, defense.
Yes, Your Honor. I have spoken with my client's mother, who is present in court today. And my client, Mr. Herrera, is actually currently living with her. They both explained to me that if he does go and attend the services, he will be accompanied by his grandparents as well as his parents, his mother and his stepfather. So he can actually be supervised by 4 other individuals. While he's there, it's going to be for limited services from 10 a.m. to 1 p.m. This is a church that they've gone to for a few years now, and they expressed to me that while it is true that normally there are children at church services, in this particular church, there is not that many. But again, he will be supervised with his parents. He will not be alone with any children while he's there, and then he would be returning home after services.
All right, is the church aware of what he's charged with?
That part I do not have the answer to, Your Honor.
All right, then the court will, before the court will make a decision, the court needs to be made aware of whether or not the church is aware of what his charges are. And then at that time, the court will consider your motion. But it
Okay.
needs to be a letter or something from the church stating that they're aware of what his charges are.
Okay, I can provide that, Your Honor, once I've figured out that information.
All right, and then the court will make a decision on whether or not the court will allow church services. But normally, a lot of church services now are online. So does St. John's Lutheran have church online?
Actually, Your Honor, that's actually the second thing I did want to approach to the court to make the court aware. As the court knows, I'm relatively new to the case, but I have been working on the case. And in doing so, I've been speaking with my client, Mr. Herrera. As I'm speaking with him and also reviewing the discovery, I've had several what I call red flags that have come up in communicating with my client, that I think that there may actually be a competency issue here, specifically with regards to any electronic use.
Mhm.
So that is why when I actually did consider that myself, is whether or not he could be able to watch church services online. I think that may pose that difficulty because of this competency
All right.
issue.
And then, and I'm aware of the charges. And when I was thinking of watching church in line, of course, it would be with his uncle or his parents, somebody being there as well.
And to that regard, that's why I waited for today to make the decision on whether or not I was gonna file the competency request. I spoke to his mother, and his mother also expressed to me her own personal medical mental health disabilities. So I kind of think that it may all be tied together, which is why when I get back to the office, I will be filing that motion for competency review.
Okay, all right. And then with regards to the motion that we're here on today, once I have information from the church, then the court can make a informed decision on whether or not I will allow that.
I understand you.
And I'll note that you're going to file that motion today.
I should have it filed today. I don't foresee any other obstacles, but we never know how my day goes, like everybody else.
Oh, there you go.
Yes.
But if we greet the day with smiles, no matter how it goes, it's all okay.
If we're positive about it, I agree. So that is my goal, Your Honor.
All right, just get your reset form from Ms. Ferguson and we'll be back on March 23rd.
Okay, thank you.
Sure. Sure. Court is calling 2022. If everyone could please whisper 2022 CR 10140, State of Texas versus Leroy Johnson. Can I have parties announced for the record for the state?
Jason Gearhead, Your Honor.
Defense.
Robert Porter for Mr. Johnson.
And are you Mr. Johnson? We're here for sentencing. You entered a plea of no contest on January 19th. You made an application for deferred adjudication. According to the plea bargaining agreement, the state waived the deadly weapon allegation. Punishment was to be assessed at a cap of 6 years in the prison, and the state is silent on your application. They're taking certain items into consideration, and there's to be restitution, if any, to Hector Vega. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
All right, any objections to the PSI report?
Not from the state, Your Honor.
Defense?
Your Honor, yes.
All right, what are your objections?
We're standing before the court saying that the court is being misled as far as the cap evaluation.
Right, I'm sorry, just a moment. Excuse me, in the box, if you all could either whisper or not speak in the box while we're on the record so that the court reporter can hear. All right,
I'll speak up a little louder, Judge.
thank you.
We're going to stand before the court and say that the cap evaluation is not correct, nor if anything else was correct as far as his drug use is concerned.
All right, so what is your correction to the tap?
He does have a drug issue, Your Honor. Ecstasy and meth daily. At issue, Judge, is we visited about what was going on and why we're doing what we're doing today is simply this. You know, Mr. Johnson was always thinking, okay, what's the easiest way that I could get out the quickest type of deal. After he did this evaluation, we got to thinking about it. I said, no, I need help. I need to do that so I can quit lying to myself and quit lying to society, quit lying to everybody. And I said, well, you've told them this, and that's not true. That is true. And I want drug help. So I guess my objection would simply be that when they're sitting there saying that there's no recommendation that it's just cannabis use and then alcohol way back when. It is true he doesn't drink much alcohol at all, or use marijuana much, but he uses ecstasy and
All right, anything else with regards to the actual report?
everything else is fine.
All right, anything you wish to say on behalf of your client?
Your Honor, having said that, it was refreshing to actually have an individual sit there saying, have reflection, and I'm sitting there to sit there and say, you know what, this is crazy for me to be doing what I'm doing. I do want help. So respectfully requesting this court to grant his application for giving drug treatment.
All right, so what the court has concern about is number 8 in the PSI report. It's on page 5. And I'd like to know what is meant by this type of behavior before.
Well,
That's what the complainant is saying. The complainant says that he's engaged in this type of behavior before.
no. Well, Judge, I don't think I could speak.
I'm so sorry. That's me misreading. He stated that if the defendant has a history of this type of behavior, he does not think he should get probation. But if this wasn't an isolated incident, he can understand him being given another chance.
Right. So
I'm sorry, my misreading. So, Mr. Johnson, you waived your right to remain silent when you entered this plea. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth to help you God? All right, you can lower your hand. State your name for the record, please. All right. So I'm gonna need you to speak up so that I can hear.
Oh, Leroy Johnson.
So explain to me about your drug use.
I take ecstasy every day, like all day. That's it. So much ecstasy, I get delusional.
I can't hear you.
I said after so much ecstasy, I guess I went delusional. You know. Went outside. Shoot.
Are you in your children's life at all?
Yes, ma'am.
Why? Because it doesn't appear that you're a good parent.
I don't always do that. I went delusional. I was seeing.
No. I want you to focus on the questions that I'm asking.
No.
My next question for you is, are you in the lives of your children?
Yes, ma'am.
How often had you been seeing them before this?
I have my children there all the time on the weekends and holidays.
Who's letting you have children on the weekend and holidays when you use ecstasy daily?
I'm still a good parent.
All right, let me ask you a question. How old are your children?
10, 7, and 8.
All right, so they're 10, 7, and 8.
We're going on, 10, 7, and 6.
10, 7, and 6, right? All right, so let's say you're going to have your children for the weekend, and you want to have your children for the weekend. An emergency comes up, and the mother of the children and no other relative can keep them. But somebody tells you, hey, I know someone who's a great babysitter, and it's me. They tell you, get Stephanie Boyd. I know you have your emergency. She's a great babysitter. You say, I don't know. And somebody says, well, let me give you her references. They give you my references. You call and check. Everybody says, Stephanie Boyd is a great babysitter. And as a matter of fact, she's the best babysitter in the world. And you say, well, I still don't know. Let me just have her come over and see if my children like her or not. So you stay with me and you stay with the children for an hour. The children love me. They're all over me saying, Daddy, please let her be our babysitter while you go off on this important thing you have to do. And finally you say, okay, Stephanie, I'm going to want you to call me every hour, but I'm going to let you babysit my children because children like you. And I got all these great recommendations from everybody saying you're great. You don't have any criminal history. I'm going to let you babysit my children. And I'm excited because you're saying, I'm going to pay you $70 an hour. I'm like, great. And so as you're leaving, I say, well, there's something I really need to tell you that you may not know about me. I use ecstasy every day. When I tell you that, do you let me babysit your children?
No.
So you have been the parent or the babysitter who's using ecstasy every day, babysitting your children. And that means you're not a good parent. Because if you thought you were a good parent and using ecstasy, you would allow someone to babysit your children who use ecstasy. Do you understand? So I will tell you this. I'm going to give you a choice. And Mr. Porter will tell you, sometimes I can give people choices, sometimes I cannot give them choices. I can place you on probation. I'll give you a deferred adjudication, but you're going to safety because felony drug court will not accept you. We can have them look at you, but they're not going to accept you because of this gang affiliation issue. So you can either wait and go to SafeP. SafeP is a 9-month program. SafeP, you're going to spend 6 months inside the facility. And then there's 3 months of aftercare. So you can do that, or I will sentence you to 4 years prison. So you can discuss that with your attorney. Mr. Porter, do you need to discuss that with him?
I would like to, Your Honor.
Then, Mr. Ferris? Your name always, I'm sorry, it's Paris Ferris. So your parents name you Paris? Is that after the play, Shakespeare play, or is it after the city?
City,
Oh, okay. Your parents love Paris?
she wanted to go.
Ah, okay. Not Paris, Texas, though. Okay. All right, so today is the day where you make a decision on whether or not you're accepting the state's offer. Do you understand?
Yeah.
All right, and so your attorney is telling me that you're rejecting the offer. Are you requesting a jury trial?
Actually, I accepted, but
All right, let's do this. I'm gonna step out the room. So if you want to put the offer on the record for him, you can. Okay. And then I'll come back when you all come get me outside, okay? I don't have, oh, it's up next. All right, Mr. Dominguez, your attorney is not going to be here today. Your attorney has some health issues.
yes.
So my understanding is that he's been in contact with you, so we can do one or two things. We can reset this case, in which case what will end up happening, we'll reset it and we'll see how your attorney is doing. And or either if you wish to have another attorney, we can do that as well.
The only thing that I knew about him is that this case was supposed to be for a bond reduction today.
Well, I mean, we're not going to do a bond reduction today because your attorney is not available.
I'm not sure what to do. I mean, I don't know anything of him. I knew that he was in a coma. I mean, that's the only thing I knew.
Mhm.
I'm not sure if you could get another lawyer or.
All right, we'll see about appointing you another attorney, all right? Just have a seat in the box and we'll go from there. And Ms. Ferguson, if you could look and see. All right, so the last time we were here, partial GPS was agreed to. That was on the 20th. And then on the 15th, we had some HIPAA release for child was granted, autopsy completed, CPS records, 911 calls needed, state to provide info on upgraded charges. So we're here to see about that.
So I do not have them on the upgraded charges at this point. The discovery, I believe, is complete. What are you still missing?
911.
The 911 call? Okay, well, I can leave that easy enough. I would still like a brief period of time to get a clear answer on how our office would like to approach this.
So I'm assuming, I guess you have to go up the chain of command or something.
Yes,
All right, so this is what the court is going to do. The court is recalling this in 45 days. The court is not going to have any more resets dates for what the state is going to do. We will end up going to trial on an endangering a child, and because that's what I have before me.
understood. Your Honor.
All right, Ms. Ferguson, I need a 45-day reset on Stevie Stokes.
March 30th.
All right, so we're going to come back on March 30th and state provide info.
And if I have information before that, I have a pretty open communication with Mr. Piddle, so I'll let him know.
All right, is there anything else?
That's it, Judge.
All right, Ms. Ferguson, we'll give you a reset form. You're excused. Who's here on Sarah Rodriguez?
For your honor.
Where's Rodriguez? Please come forward. All right, you were late for court. Why?
The court didn't move and the elevators weren't working, so I had to come up the stairs.
All right, we've been in this court since January. And it shows here that you were here on January 19th. So again, why were you late for court?
I mean, the elevators weren't working, so I had to come a different route that I haven't come before. So I went up the stairs and went on, I guess, the second floor.
All right, so here's the thing. I don't allow people to be late for court. I'm on time for court. I go through the same traffic that everyone else goes through. And what I do is I pad my time to anticipate traffic, to anticipate school zones. You understand?
Yes, ma'am.
So you need to make sure you're on time. I'm going to note that you were late. Do not be late again. You understand?
Yes.
All right, so today is her plea deadline date. What's happening?
We just received a new plea bargain from the state. There's also some additional information that's going to be provided to me in a memo form that I haven't received yet. So we'd ask for just another plea deadline if we could in a couple of weeks so that we can go over the new information and talk about the new plea bargain.
All right, Ms. Fergus, can we recall this on February 16th?
Okay.
All right, your plea deadline date is February 16th. The court will not extend the plea deadline date any further. Do you understand? All right, so Ms. Ferguson will give you a reset form.
Thank you, Your Honor.
You're
May we be
welcome.
excused?
Yes, after you sign the reset form.
Yes, ma'am.
All right, so what is happening with Mr. Gonzalez?
Judge, let me go first, if I may. Judge, I've just started conferring with Brittany as she just got assigned this case this morning. We brought some things to her attention that we would like her to consider in a plea remedy. And so I'm going to kindly ask the court for another plea deadline, but I think we may be beyond that, Judge, but I don't think this case has that many settings.
So specifically, where are we? Because last time I was here, it had to do with CPS records. So the court signed off on the release of the CPS records. So is there any discovery that you don't have?
No, Your Honor.
Okay, so all discovery has been tendered.
Yes, sir.
All right, I'll need a discovery acknowledgement signed today.
Yes, ma'am.
Now, the next question, state, are you prepared to make an offer or no?
I would like to talk to the parents of the victim one more time.
All right, so Ms. Ferguson, I need a 30-day reset on Mr. Gonzalez.
March 23rd.
All right, we're going to come back on March 23rd. At that time, state you need to be prepared to tender an offer. Mr. Gonzalez, you'll receive an offer either on the 23rd or before the 23rd. Then after the 23rd, I will give you a plea deadline date.
Very
You
good.
understand?
Okay.
All right, is there anything else?
No, ma'am.
All right,
so
thank
much.
you. All right, what is happening with Mr. Gonzalez?
We have, as the court may recall, there was a psychiatric
Yes.
evaluation requested. We have another appointment to finish it up on the 17th of February. They changed a little bit of the medication. And we can get the formal report, we're hoping within a week or so after that. He's made all the conditions, all the meetings, doing well.
All right, Ms. Ferguson, are we able to put Mr. Gonzalez at the end of the month or beginning of March?
Whichever date you want.
Let's do the first available date in March.
I can do the
All right, so we're going to be back on March sixth, Mr. Gonzalez, and thank you for dressing appropriately for court. I appreciate that. All right, so we'll be back on March sixth at 9 a.m.
Very well.
Thank you. All right, they'll give you a reset form and then you're excused. All right, and Mr. Bach, I know that you were recently appointed. Oh, your client should be in the middle. All right, so Mr. Dominguez, you've had a chance to speak with your attorney?
Yes, sir.
All right. So what we're gonna do, this is the first time your attorney, this attorney is being here. So we're gonna give your attorney a reset. If your attorney wants to come back sooner, he's more than welcome to let us know and we'll put it on the docket sooner. But I'm gonna give him a 30-day reset because that'll give him a chance to look at any discovery, okay?
Yes, yes, Judge. Yeah.
All right, Ms. Fergus, can I have a 30-day reset on John Dominguez, please? All right, so we'll be back on March 21st at 9 a.m. Mr. Ramirez, we normally don't have pre-indictment cases set in this court. But counsel, if you want him brought back on a specific day, we can do that.
Then it's work. Let me work it out with Mr. Graham. If we can work it out, then I'll call this.
Ferguson,
I was gonna, for some reason, I called him Frank. I want to call him Frank.
that's okay.
Ferguson. We'll set it for a few weeks or something out.
All right, so Mr. Ramirez, what's going to end up happening is that if your attorney wants you placed on the docket again, he will request it and we'll have you brought over. But I'll note that you asked that the motion for the PR bond be withdrawn, okay?
Yes, ma'am.
All right, thank you.
Thank you.
Thank you. All right, Ms. Ferguson, on Mr. Pettis, I need a 30-day reset for discovery. So what will happen, Mr. Pettis, is in 30 days, the state should have all their discovery. The defense should have all its discovery. The state should tender you an offer. And then the next date that you will receive will be your plea deadline date, okay?
Yes, ma'am.
Okay. All right, just sign the reset form and we will see you back on March 21st.
Thank you, Judge.
All right, you're welcome. All right, so on Mr. White's case, we're going to come back in 30 days, and in 30 days, everything needs to be completed.
Hopefully, I'm not the one that's slowing things down, I promise you.
Okay. All right, Ms. Ferguson, I need a 30-day reset on Mr. White. All right, we'll be back on March 21st. I'm writing that this is the last reset for this matter. Are the parties ready on Domingo Martinez?
So you read my mind. I was just coming up to.
Yes.
research on that.
All right. Okay, so what is with Domingo Martinez?
So, Your Honor, the basis for my opposition to that is the fact that the victim is the wife who would be going to Mexico with him, and the lack of supervision in Mexico. He does have some prior federal history, but that was about 20 years ago. So it's just a matter, I don't feel comfortable agreeing to him go to Mexico with her.
Okay, I will tell you this, just so you're aware. The previous prosecutor agreed to him going. So I don't know if you were aware of that.
You know,
I will show
I go
you.
in the middle. I don't know. Be silent. I am not staunchly opposed. I am just.
So they've had him go there before.
Oh, he's been before?
Yes.
Okay, well, he's been before and he's come back. I'll be okay with it. I guess I had thought he had been denied before. I didn't realize he had.
All right. Ms. Abrams, on Mr. Martinez, he's allowed to travel, but we'll follow the same rules as your analysis within 24 hours of return. All right, thank you, Mr. Martinez.
Thank you, Judge. Have a good day. Am I dismissed, Judge?
Probation will be in touch with you.
Okay,
Do you need to speak to him now or no? All right, just call your officer.
okay. Thank you, Judge. Have a good day.
All right, on this one, there were some issues with the discovery on extraneous offenses. Have you received that?
The state said that they provided that, uploaded that prior. I requested discovery yesterday and it just turned green, so I
Just check and make sure that that's uploaded.
So has it been uploaded or no?
I'm not sure. They told me just now that they uploaded it, so.
Okay, so it's been uploaded just now?
Yes. What the discovery, he said the extraneous conferences were uploaded to the Bear system and I just requested them, so, okay. If he says they are,
All right, so are they uploaded, State?
I would have to check. The prosecutor she was conferring with has left, so.
Okay, so the prosecutor informed me that it's been uploaded.
I believe them.
Okay.
They told me they would.
Okay.
I don't-
All right. So has an offer been tendered to you?
No, it hasn't, Your Honor.
All right, so Ms. Ferguson, on Mr. Robinson, I need a 30-day reset, please. All right, we're gonna come back on the 21st, and on the 21st, State, you need to be prepared to have made them an offer. And then, Mr. Robinson, your next date will be your jury trial date and plea deadline date. All right, do you have any questions? Yes, they'll give you a reset form.